We move on then to consider the fourth head of charity from Pemsel, that is normally regarded or said to be the general utility head of charity. Now this head is many and various, and there are examples in the textbooks of the sorts of things that might be included. The courts refer back to the spirit and intendment of the preamble to the Statute of Charitable Uses in determining what falls within this head, though it has to be said that they do so in a fairly loose sort of way. The process might be regarded as an evolutionary one, the courts taking the view or taking note of the fact that times change, and that what was charitable once may not be a good notion of what should be charitable today. Thus, for example, in the Scottish Burial Reform case in 1968 in the House of Lords, the House of Lords had regard to the preamble to the extent that it refers to the repair of churches. From that it might be inferred that maintenance of burial grounds is covered, and thence to promotion of cremation. So you can see this is an evolutionary process. It doesn't have to fall exactly within the preamble itself, merely within its spirit and intendment in the light of modern circumstances. An issue that arose in the 1950s, in actually 3 House of Lords cases, but 2 of them are on the PowerPoint slide, was that if the purpose had a large social or recreational element, then it could not come within the fourth head. And we see that in IRC and City of Glasgow Police Athletic Association and in IRC and Badley, in both of those cases, a purpose failed to fall within the fourth general utility head on the grounds that it had a large social or recreational element, even though it might otherwise have had a significant general utility element. It was really in reaction to these cases that the Recreational Charities Act was enacted in 1958, which allows it to be charitable to provide for recreation or other leisure time occupation. However, there has to be a public benefit, as of course is the case with all charities, but also the facilities have to be provided in the interests of social welfare. That is a requirement for this head of charity alone. The definition of social welfare is filled out in section 1.2 of the Recreational Charities Act and includes provision of facilities either for people who have a particular reason for them, for example because of youth, age, infirmity, disablement, poverty or social and economic circumstances, or are to be available to members of the public, male or female, at large. Subject to this, however, there does not appear to be any other particular definition of social welfare, and the courts have not adopted any particularly narrow definition of social welfare for the purposes of this Act. Thus, for example, the House of Lords considered in Guild against IRC in 1992 that the provision of a sports centre, for adults this time, not for children, could be charitable within the Recreational Charities Act 1958, and that the social welfare requirement did not specifically require recipients to be deprived. This was an issue that had arisen in earlier House of Lords and other cases and was finally resolved in Guild. It can therefore be charitable to provide sports for adults, subject only to the public benefit requirements, and also that the purposes be generally available to members of the public. For example, presumably if the price was extremely high, then it would not be charitable because it would not be regarded as generally available. We should also notice the categories listed in the Charities Act 2006, which, as I say, now provides a statutory definition of charity. Many of these, I think, are already encompassed within the fourth head, but some are not. The advancement of citizenship or community development is, I think, new. It might just be clarification, but it might also be extension. The advancement of the arts, culture, heritage, etc. was considered in re-opinion, and presumably this is nothing new. Amateur sport, again, we have already considered. Human rights and so on probably is new and in line with modern legislation. Relief of those in need by reason of youth, age, ill health, disability, etc. was probably already encompassed within either the poverty head or the fourth head, and the advancement of animal welfare was within the fourth head, as was the promotion of the efficiency of the armed forces of the Crown and the efficiency of the police, fire and rescue services and so on. But advancement of environmental protection or improvement is also new. It may again be clarification, but it might also be an extension. The Charities Act 2006, therefore, should not be regarded as a radical reform of the law. It clarifies the existing law. It removes no purposes that were not charitable before, but it might add a small number of new purposes in order to bring charities law up to date.